I'll start in Spanish. Hi, Mark.
Hello, Pablo. Hey, Barry. Everyone.
Bueno, buen día, buenas tardes, buenas noches, como decía en el mensaje. Good morning, good afternoon, good evening. Y bienvenidos a la sexta actividad del IDC. Como ya anticipamos, hoy los tres speakers son básicamente angloparlantes, con lo cual el idioma principal de hoy va a ser en inglés. Así que voy directamente a hacer una presentación muy breve en inglés. Vamos a dar unos minutos para que la gente se vaya conectando. Welcome everybody, this is the sixth IDC activity. I'm going to mute everybody and then we will open the room to our speakers. As I said, we had participants from Australia, Europe, America, the Americas. So approximately 13 time zones separate us all today. This is, in my opinion, a milestone on IDC's incipient history, because the three panelists we have need no presentation in the antitrust and competition law global community. While I admit everybody, let me give a brief presentation of our three speakers today. As we all know, today the main purpose is to have Barry Hawk, who will be our keynote speaker, and also present his new book, Antitrust and Competition Laws. Barry is a leading expert in antitrust law. He's a former partner at Keynote. He's a former director of the former Competition Law Institute from 1974 to 2015. He's a former professor of US and international antitrust law at Fordham also, Michigan Law School, Monash University in Melbourne, NYU Law School, and the University of Paris. He's also the author of many books and articles on antitrust and competition law and policy, including the annual volumes of the Fordham Competition Law Institute. As I said, we will have Barry as our main speaker. He will use approximately 25-30 minutes of his presentation. And then we'll have two very prestigious commentators. The first commentator will be Eleanor Fox. Eleanor, as we all know her, she's a professor at NYU. She's also an expert on antitrust and competition policy. She teaches, writes, and advises on competition policy in nations all around the world and in international organizations. She has a special interest in developing countries, poverty, inequality, and she explores also how opening markets and attacking privilege, corruption, etc., in order to alleviate the marginalization and open path to economic opportunity and inclusive development. She received an honorary doctorate degree from the University of Paris, Dauphine, in 2009, and she is the author of books, articles, case notes, and book reviews on various aspects of international competition law and policy. Last but not least, our second and last speaker, second commentator, would be Ian Forrester. Ian is the UK's judge at the General Court of Justice of the European Union until Brexit. He also served as an arbitrator in the ICC and the ICSID proceedings. He has an honorary Doctor of Laws, an honorary professor also of the University of Glasgow. He's an advocate of the Scottish Bar. He's also admitted in the English Bar and the New York State Bar. He regularly lectures on European law and policy, and he's the author of numerous articles and chapters on competition law, legal privilege, science, and good regulatory pricing, trade policy, customs, dumping, etc. So there are still some people. I'm admitting some other participants. The three of them, this is also important for the IDC, the three of them have accepted to be members of our IDC International Advisory Board, so we are really very honored to have the three of them on board. We will have a Q&A session once we finish with the last commentator, one Ian finish his comments, we will open to a Q&A. So if you want to send the questions while the speakers or the panelists are giving their presentations, please use the chat down there in the middle of the screen. You can send the questions and we can read them, or if any of you want to interact with the participant, the speakers, you will definitely be able to do so. This is also being broadcasted live on the IDC YouTube channel from now. So we're starting with that right now. So with no further ado, let me give the floor to our main or the keynote speaker, who's Barry Hawk. Barry, the floor is yours.
Pablo, thank you very much. Thank you, everyone. I wish I were with you in person. As you may remember, my son and I spent a wonderful 2 weeks last December in Buenos Aires, Patagonia, and Santiago. And I was hoping that this book would give me the excuse to return, but that hasn't happened because of the virus. Okay, the book, which the manuscript goes to the publisher in 2 weeks. So this is the last that people can force me to rewrite things, right? Because in 2 weeks I go to the publisher. The book discusses 4 time periods in the history of competition law. First, the pre-modern world, pre-industrial world, and I include in that discussions of Athens, classical Athens, obviously, Rome, India, Imperial China, Islamic world, and post-Roman Europe. So that's stage 1. 2 is US antitrust law. 3 is EU competition law. And 4, there's a chapter on I'm calling post-1990 jurisdictions around the world. Okay. Let me quickly, my presentation this morning is going to center around 5 conclusions rather than a summary of the book or a summary of the four periods, right? But let me just very quickly give you a couple of highlights about each of the 4 periods. Okay, the world before 1980. I examined pre-modern laws, pre-industrial laws, according to kinds of conduct, monopoly, cartels, market interfering practices like forestalling and hoarding, price discrimination, excessive pricing, a lot of interesting, let's say parallels, but comparisons that one can make between particularly European rules, medieval rules on just prices and modern rules on excessive pricing. And last, restrictions on freedom to trade. Okay, so that's how I divide the world rather than a chapter on India, a chapter on Islamic. Right? Now, there's a major caveat. Historical sources are not user-friendly for modern researchers. Pre-modern laws do not fit into modern competition law categories. For example, the modern distinction between horizontal agreements on the one hand and unilateral dominant firm conduct on the other hand were not made. That distinction was not made in pre-modern times. What we consider today as cartels frequently were condemned as monopolies in the prior period. And we'll see this a bit later. So what does this mean? One thing is it's very easy to manipulate the historical record to prove your modern argument. So if your argument is, well, since the beginning of time, people have condemned monopolies, or there have been laws against monopolies, cartels, well, the historical record is far more complex than that. Now, competition or antitrust laws, and I'm not making a distinction between those two, you can find evidence of competition laws going back at least as far as classical Athens, and more clearly in the Maurya period dynasty in India, which is roughly 3rd century BC, and perhaps as far back as the Mesopotamian cities. That requires more research in Assyrian. with asking questions that have not been asked in the literature, right? But there may be evidence there of even anti-cartel, I won't say anti-cartel laws, but competition laws as early as Mesopotamian cities, which is 4,000 years ago. Now, in these pre-industrial societies, which was the entire world before the 19th century, sudden increases in grain prices commonly were blamed on traders and producers who were condemned as monopolists. That's why I've got your picture up here. It's food rioters. That's the most common situation that generates laws and enforcement of laws that today we call competition laws, or that look something like competition laws. So you had food riots. The people demanded action against the price hikes, particularly in grain, and rulers responded out of two related concerns: a political concern for social stability, they wanted to prevent revolution or regime change, or a moral concern for social justice, to promote the welfare of their citizens or subjects. And the laws were enforced to combat not only conduct condemned under modern competition law, like concerted price fixing, but practices like forestalling. Forestalling is buying goods before they get on the market, or price speculation, or hoarding. And those kinds of practices like forestalling are generally no longer considered unlawful under modern competition laws in light of modern economic theory and, very importantly, changed economic conditions. Okay, so the first stage, everything before 1880, which was the beginning of state antitrust laws in the United States, food rioters were responsible, by and large, right? The second period in the history of antitrust law is the US. It's 1880 state antitrust, states began, introduced and enforced state antitrust laws, and in 1890 you had the Federal Sherman Act. Now, the modern antitrust world, which began with the US antitrust, began with popular complaints again against, quote, monopolies that were made for millennia against grain speculators. But the grain speculators were replaced with new targets, large private firms. And the industrial world toward the end of the 19th century generally reacted in two very different ways to the growing power of large firms and monopolies and cartels. But we'll stay with large firms. In Europe, government authorities and courts viewed large firms as largely beneficial, and the political power necessary to challenge private monopolies and large firms, or even cartels, was absent in Europe until we get to the next stage, the post-World War II. Now, the United States took an entirely different position toward large firms and cartels. What most distinguished the United States from Europe and the rest of the world, industrial world, was a deeper distrust of both public and private power. The American distrust of private power complemented a distrust of public power, which is reflected in the constitutional framework of checks and balances. And the first US federal legislation targeted private monopolies, not only for their economic harms, but more importantly, for their perceived political and social harms. Indeed, economists of the time in 1890 scorned the Sherman Act, thought it was sort of silly. Okay. The third stage is post-war Europe, which is primarily then the EU and Germany. The next phase, you had Europe, the EU and Germany adopted competition laws in the 1950s, partly under the influence of US diplomatic and financial pressure. Unlike US antitrust laws, the EEC treaty competition provisions were intended primarily to prevent private and public obstacles to the primary treaty objective, which was a common market among the 6 original member states. So market integration was the goal, the primary goal. Yet the competition provisions had a wider effect of contributing to the acceptance throughout Europe of an essentially free market economy with both private and public firms subject to competition rules. The fourth period, post-1990 in the rest of the world. The parents, here I'm talking to an audience who frankly knows a lot more about why post-1990 laws were enacted than I do. So hopefully I will get some critical comments here. The way I see it, the parents of the post-1990 laws differ considerably from the pre-industrial food rioters, American small business, and EU statesmen who were responsible for the three sets of earlier competition laws. The parents of the post-1990 laws are as much foreign as domestic, notably the international lending institutions, the EU as an institution, and to a lesser extent, the US antitrust agencies. So in the decade after the Berlin Wall fell, competition laws proliferated around the world. And today we have throughout the world, in almost every jurisdiction, we have the triad, the modern triad of laws dealing with restrictive agreements, dominant firm conduct, and merger control. Okay. Now, that's my summary of arguably 4,000 years of competition laws up to today. I'll center the rest of my comments around 5 conclusions that I offer. All right, conclusions. And some of these conclusions to varying degrees are relevant to the present debate, particularly in the US, but not only in the US, about the effectiveness of modern antitrust law to meet modern problems. Okay, so I'm not going to further summarize and get into all kinds of, for me, wonderfully interesting historical questions of the prior period. And maybe that's another post-virus talk and I can come down and see the Atacama Desert. Okay, the first conclusion. I think, in a way, these conclusions would be banal to a non-antitrust lawyer, to somebody not in the antitrust community. But they may not be totally banal, and may be very debated within the antitrust community, right? First conclusion, competition law historically, but all the competition laws, I'm generalizing, changes to reflect first economic conditions, the facts change. That's the hardest to show, to prove. Second, developments in economic theory. Third, political interests, which you might call economic policy. And fourth, and this is probably only in the US, although I'd love to hear, oh no, our courts do the same thing, legal process concerns. That's concerns about not due process, but legal process, like administrability of legal rules, the costs of litigation, the cost to administer the rules. Those kinds of concerns we'll see are critically important in the US in the last 50 years to narrow US antitrust law. I don't see, or I haven't seen, but I haven't read every case in the world in the last 50 years, legal process concerns highlighted outside the US. Okay, so when you look at that first conclusion, one thing I'm saying, it's a combination. I'll offer examples of different combinations of these 4 factors, right? But one thing that stands out, it's certainly not only economic theory that explains developments. That means, maybe for the US people, and you won't hear this again, I do not look at the history of competition law or US antitrust law in terms of antitrust schools. When I see the word school, that frequently suggests to me the end of creative thinking. So I'm very skeptical about schools, either the Chicago school or the liberal school. I think this is more for law professors and academics than it is the actual development of the law. That's my own, okay. So let's go to the first conclusion. Both economic facts and economic theory reinforce each other. And the theories are often developed to explain the changes in the economic conditions, with Alfred Marshall, which was the chief economist, even he recognized. Okay, not even he, I mean, basic theoreticians of modern economics recognize that they mutually reinforce each other. Okay. One example of the changes in economic conditions as being critical was in the abandonment of the English bans on forestalling, as well as the expansionary period of US antitrust law. So I'll return to that. When you go to the third element, which was politics, I'm using politics neutrally here. It's not a bad thing, politics, the way I'm using it. Politics is an important element in the history of competition law. The interests of the state, that's rulers and elites, business, consumers, and others are affected in different and sometimes conflicting ways by changes in economic, social, and other conditions. This is sort of a fundamental historical idea of mine, right? Not just me. And the political process is the mechanism through which law reflects the strength of these disparate interests. Perhaps more often than not, the facts or the economic conditions change first, and with different effects on the different stakeholders. Economic theories then follow to explain the new facts. The prevailing political interests then select among the economic theories that favor their interests, either out of intellectual agreement, self-interest, or I would guess probably most commonly, a combination of the two. So the prevailing political interests select economic theory among the theories. I think this is clearly seen with respect to the European abandonment of anti-telc enforcement in the 19th century, to which we will return. Another example of the critical role of politics, not simply economic conditions or theory, is the turnabout of US antitrust policy in Franklin Roosevelt's second term beginning in 1937, okay? When the very pragmatic president, Roosevelt was very pragmatic, put it mildly, right? He shifted US economic policy 180 degrees. His first term was cooperation among large firms to meet the problems of the Depression, economic problems. In his second term, 180 degrees, well, it's not cooperation now. Now I want competition, all right? That change did not result, there was no change in economic theory in the academy. Economic theory didn't change in 1937. The political selection of economic theories changed. That's my point. Okay? Now, let's turn to 5 examples of pre-modern and modern laws that have changed to reflect this varying combination of facts, theory, politics, and apparently uniquely in the US, these legal process concerns about clear rules and cost of litigation. First scenario, combination of changes in economic conditions, theory, and politics. In other words, everything but legal process concerns, already mentioned. 2 examples of that are the European bans on forestalling and US antitrust law. Regarding the abandonment of European bans on forestalling, first, the economic facts changed. Let me go quickly. You have laws against forestalling in Europe, clearly evidenced as early as the 12th century. So for hundreds of years, you've got laws very episodically enforced, usually enforced only during times of famines when the grain prices go up, throughout Europe. All right, and they begin to end in the 18th century, right? So we're talking about more than half a millennium of laws banning forestalling. Okay, why? Well, the facts changed. Agricultural markets became less localized and isolated with reduced transport costs, better dissemination of information about supply and demand, and removal of trade barriers. And these changes in economic conditions were recognized in new economic theory that argued in favor of free markets and deregulation. And the newly empowered business and commercial interests who benefited from free markets in the 18th century, early 19th century, they unsurprisingly embraced these new economic theories and added the legal doctrine of freedom of contract in England to further advance their interests against bans on forestalling. And this combination of new economic conditions, economic theory, and the political importance or weight of the commercial interests eventually prompted the British Parliament in 1841 to repeal the century-old bans on forestalling. The second example of changes in competition law reflecting a combination of changes in facts, theory, and politics is the expansionary era of US antitrust law from 1937 to approximately 1980. As I just mentioned, FDR's political support in 37 was critical. They didn't change the statutes. You suddenly totally changed the enforcement. Okay. Then as far as the economic conditions changed, again, this is the hardest to show certainly from the case law. All right, so this is for researchers. Go read 1,000 cases seeing reference to changed economic conditions. That would be wonderful, right? The economic conditions changed certainly after 1945 to 1980. US firms were relatively free from foreign competition, given the still existing trade barriers to entry and the economic weaknesses of potential foreign competitors. Therefore, it was reasonable to assume that any market power enjoyed by US firms would be expected to persist. And the success and dominance of US firms reduced the risks that aggressive enforcement would chill innovation or pro-competitive behavior. Therefore, you didn't have to worry about false positives so much, okay? Then that's a change in economic conditions. Economic theory changed, or the economic theory that was used in antitrust analysis, right? That also supported an aggressive application of US antitrust law. Industrial organization economists formulated the structuralist paradigm, which held that market structure leads to and correlates with bad performance. Right, so you had politics at the beginning. You had changed economic conditions, which suggested that firms' market power, US firms' market power would persist absent government intervention. And economic theory supported application of antitrust law to deconcentrate markets. Okay. Let's go to another category. Second category is, stop me when Pablo, give me when I've got 10 minutes to go, then I will ruthlessly cut this out. Okay.
Okay.
Next, okay, predominance of politics with support from economic theory and political conditions. Now these categories overlap, right? So here's where I'm talking about monopolies and cartels. My basic thesis is that, in a nutshell, you had for monopolies throughout history, intellectuals, religious figures, and certainly the people understood that monopolies raised prices and condemned them. Okay, Muhammad said, whoever monopolizes is a wrongdoer. St. Basil condemned traders. Charlemagne denounced as monopolists those who by tricks, surprises, and other unjust means amass goods with the aim of a shameful gain. So for thousands of years, Aristotle is the first in the West defines monopoly as a single seller, okay? And he condemns monopolists, right? So you had, people were aware of the economic harms of monopolies. And you had laws that condemned monopolistic practices like forestalling and hoarding, but they weren't dominance or monopolization laws in the modern sense. Monopoly was used as a term of opprobrium to condemn usually price-raising practices that raised prices of grain during famines. Okay. you had laws, but I think my thesis is they probably weren't enforced very often, and they're a minority. A famous example to show that the West has always been against monopolies is a well-cited edict of the Roman Emperor Zeno in the late 4th, 5th century, which prohibited monopolization of necessary foodstuffs. And it's the first recorded use of the term monopolium in Roman law. But, and it's heavily cited by medieval, particularly starting with the Italians in the 12th century, of using Zeno's edict Constituzione to derive an anti-monopoly principle. Well, how effective was it? Well, very soon after the Zeno, emperors like Justinian created monopolies, state monopolies, sanctioned private monopolies. So history is replete. History is filled with ruler and private monopolies because rulers recognize that monopolies generate monopoly profits, and they sanctioned monopolies. They participated in monopolies in order to what? To wage war, live better, and subsidize their supporters. That's what you wanted revenues for, right? And the financial needs of rulers often led to official acceptance of monopolies, even in the face of hostile laws and public opinion, right? And I won't have time, but there's a wonderful story of the Emperor Charles V, is what, 1500s, right? Charles V. He ends up participating, he needs money. So he needs revenues, right? To live better, wage war, and subsidize his supporters, right? So he participates in a monopoly or a mining cartel with the Fugger family, right? And they were the capitalists of the 16th century, right? You had local laws throughout the Holy Roman Emperor against monopolies. Local authorities began applying the law against this mining cartel. The emperor intervenes, there's back and forth for over a decade, and ultimately the emperor prevails, right? By sending letters out to say, stop enforcing these local laws. I think the example of Charles V and Jacob Fugger are far more representative of what was happening in the world before 1890 than the religious scholars and the intellectuals and these laws condemning monopoly. A similar story, a little more nuanced, can be said about cartels. I'll give you my slides. There's your slides, monopolies, common. Sorry about this, that should have been that. On cartels, you had, I think, probably more laws that were effective, particularly grain price laws against cartels and against monopolies. Adam Smith, I think, was right when he wrote that people in the same trade will hardly get together without raising prices. Justice Scalia, the rare minimalist area, he cites economics literature, very fancy economics literature, showing how difficult it is to manage a cartel, to police the cartel, et cetera. So he raises the pleading standards for a conspiracy under U.S. antitrust law on the assumption that, well, we really don't have cartels. Cartels do not present a serious risk because of the difficulty of implementing the cartel. I think most lawyers who are either prosecutors or represent defendants that would agree more with Adam Smith than Justice Scalia. Okay. The European, again, with cartels, you had laws against cartels, but in the 20th century, you did have clear laws that were enforced to some extent against cartels in Europe before the 19th century than you do with respect to monopolies. In the 19th century, cartels become tolerated, more tolerated. All right, in England, the common law, laissez-faire, you know all this history, but a combination of factors we saw before result in a toleration, which is really for the first time, against cartels. So the way I'm seeing cartels, for European history, and the Indians were against cartels, arguably the Chinese, but it's much more difficult. But throughout the world, people had some laws preventing cartels. In Europe, those laws are tremendously weakened beginning in the 19th century until 1945. And there are few examples. For 3 years in Germany during the Weimar Republic, they had an anti-cartel law. And the liberals make a big fuss of this. It's 3 years in 150 years. So again, by and large, the cartels were accepted, I think, for political reasons, with economic theory used as support. That isn't really what it was all about. All right. The predominance of political support, I mentioned before Franklin Roosevelt changing everything overnight. The other, a more modern, another example of the predominance, but I think it's a predominance of political support and active enforcement, was a history of the first, well, EU liberalization, the EU for the first, the EEC treaty starts in 1958, it's effective 58. For the first, until around 1990, roughly, the first 30 years, EU law, competition law, was not actively or aggressively enforced against state distortions of competition. Okay, there was some enforcement, but not very much. That totally changes at the end of the 1880s and 1890s, and in the 1990s, the US very aggressively uses competition and other laws to deregulate and liberalize markets in member states. The reason for the change, I argue, is the British, particularly the member states led by Margaret Thatcher in the UK and Helmut Kohl in Germany, those two governments made the political decision to liberalize local markets. And that's, the German, interestingly, the German government effectively went around domestic opposition to liberalization by supporting liberalization at the EU level. Margaret Thatcher just took out the unions and sort of stifled domestic opposition on her own. So there again is an example of the importance of political support for active enforcement. And not, sure, the political decision rested on economic ideas. I'm not excluding economic, you will see this later. Okay. The last.
Sorry, Barry, we have 5 minutes approx.
Okay, fine. Okay. Interestingly, we can really argue about this. I couldn't find very many examples of competition law changing generally, not just obviously economic policies, very important in influencing a specific decision or formulation of a legal rule. But of an overall trend, economic theory alone doesn't seem to shift antitrust law. And one example is that the freedom of trade notion, but maybe we return to that. Okay, because it's primarily not a US audience. In the US, you add legal process concerns, concern about the administrability of legal rules. We need legal certainty, right? What are the costs of the litigation costs to run the system? Those concerns have significantly narrowed the substantive reach and the procedural system of US antitrust since 1980. Okay, and there are many examples. We have a tougher rule on, well, tougher. We have the rule on predatory pricing is much more tolerant than the EU rule because it doesn't have a recoupment element, and partially that US predatory pricing rule rests on a notion of a desire for clear administrable rules. And the courts say this, and this is well documented. This isn't professors trying to think about what do the courts really mean. Second conclusion, I'll go fast, right? economics or ideas about economic activity have always been predominant in competition law. Okay, whether the laws are motivated by social justice and social stability, or concern about large firms or market integration, the application of the laws focuses on an examination of business conduct. And business conduct involves economic activity, and ergo, economic activity is and will remain essential in the application of competition laws. The critical difference between before the 20th century and today is that the ideas about economic activity are now economics, which has become a much more sophisticated intellectual discipline. It's that degree of sophistication of the economic theory that distinguishes distinguishes modern application of antitrust from the past. I'll go on. I believe that you've always had economic ideas. It didn't, and the book goes into this. You didn't need Oliver Williamson. They understood transaction costs. They understood supply and demand. So you always had courts, always had some idea about economic activities. This is more for the, we all need a little humility. When I read some economists asserting a theory, it's commonplace for them to say, there were no economics before my theory. That's common, right? And if your theory goes one way, then you say the old theory was Chicago school, and that's not economics. I think the increasing complexity raises questions. Has economics become too complex for generalist courts? This is more US. Will these legal process concerns about administrability of your rules constrain adoption of strategic economic theories? You think, well, these economic theories now are too costly to apply. They're too unclear, so we're not going to adopt them. I think if that happens, that will limit antitrust in favor of defendants. What about that, Frank? Should competition outside the cartel area be limited to specialized agencies? Of course, that's, too much can be, I'm saying economics should predominate in the legal analysis. But too much should not be demanded of economics. Economics is not physics or chemistry, okay? It's a social science. Its principles rest on fewer empirically verifiable propositions. One of the weaknesses of modern merger control, for me, is its failure to test all these wonderfully interesting merger theories. And how you test them? Well, you look at prior mergers that have been condemned or approved in condition and see what happened. That's extremely costly, incredibly, a very, very difficult methodological, but I think this is from an outside, a physicist would look at antitrust merger review and say, what are you doing? You've got all these theories, but you're not testing them. And you could test them. I mean, that's the other thing, testing monopolization dominant firm borders on the impossible for me, right? How many minutes do I have? 1 minute? I'll stop. Certainly economics has significantly increased legal precision by distinguishing among different kinds of conduct that previously were lumped together as monopolistic, right? It's also removed certain categories. Generally today, we don't condemn forestalling. We don't condemn price speculation as such, as an antitrust violation, right? Maybe a securities law violation, right? So I don't like, economics has also generated considerable global convergence, right? I think convergence is a nice thing, but I wouldn't get obsessed with it, right? I know Eleanor has very strong views I agree with on this. Everybody's law has to be the same. No, everybody's law doesn't have to be the same, but the outcomes are the same. The big point here for me that I offer about the uncertainties of economics, I'm saying economics is critically important. You can't get rid of economics, right? You got to recognize the limitations of economics. In economics, it highlights the critical importance of assumptions. And we could spend another program on assumptions. I can't emphasize more the importance of assumptions. One assumption, just one of assumptions, which is frequently not articulated in the case law. So I'm guessing again, what are courts really doing? Is this assumption about the persistence of market power. Your assumption about persistence of market power can be used to explain the US expansionary period. It can explain the present minimalist period. It can be used to explain the EU approach to dominant positions. But it's not discussed in the opinions, and it should be. So on admonition, the courts and authorities would be, you got to reconsider your assumptions all the time. Okay, last, and I'll stop. The fourth conclusion, non-competition policy should be translated into economics-based competition rules. The best way of doing that, the most common way of doing it is through legal presumptions. Okay, and in the US, we don't do it. It's not as strong as, it's not as used presumptions as it used to be, but we did have a presumption. We still have a presumption that that a merger with market shares, a horizontal merger with market shares above, combined market share above 30% is presumed to be unlawful. Where'd that 30% number come from? I'll close on this. Well, it could come from economic theories that say we've studied, and our theory is that when you have a combined market share of 30%, that results in a high risk of unilateral or coordinated pricing. Okay, fine. You could also have political science theory or political theory saying that we've run studies showing that where there's a combined market share of X percent, 40%, I think it should be the other way, shows that there are specific concrete political harms that result. Corruption in the political process, right? My point is that you're taking the number, this presumption, which is a number, 30%. That number could reflect economic theory about coordinated or unilateral price effects. It could also, if you want to, include political theories about concentration or reflect perceived political harms. The way you would do that, you'd put it in the same presumption so that the analysis in the case is still an economic, the analysis is still an economic framework. All right, I'll stop there. Institution matters, but I'll stop. You've been very patient.
Thank you very much, Barry. We might continue afterwards with the Q&A. So now our first commentator, Eleanor, the room is yours.
Okay, thank you. So Barry, thank you very much for the book that we're about to see published, and for the thinking you've gone into it. It's really an exciting project. I'm very excited about it. I would like to make comments in 3 subject matter areas. Before I do, I want to commend you on the overall insight, which I think is exactly right, that it is not the particular economics of the day that has driven the choice of economic theory in the law, but it's that it is the combination of the economic facts on the ground and the politics in particular that have influenced the choice of the economic theory. And that is what has changed our law over time. Very important insight. So now my 3 categories. I want to claim with respect to your 4th period, which is really modern times, I see a little disassociation of your history from your 4th period of modern times. You talk about, for example, in the United States, the move from thinking about freedom and competition and free trader and competition. And you say the move is from freedom to competition effects. I would say the move, this is United States, the move is from freedom of the outsider to freedom of the insider, meaning laissez-faire. And that the economic theory that we adopt derives from that ideological choice. I see you're staying away from calling what is happening ideology, but it's part of the politics. And you're clearly, as you say, you're staying away from naming schools like Chicago School. But to me, that's very much a part of the political ideology of laissez-faire, and that the assumptions derive from that choice. So I use Chicago School to make a picture of the assumptions of markets generally work, very free markets generally work, and that those assumptions for some people, not all, that associate with Chicago School, they are interested in the freedom aspect. All right, so my second point I want to make is about, you're talking about legal process as one of the drivers of change in the United States, the fourth driver of change, the first being facts, theory, and politics. I want to contend, first of all, as I mentioned in a note to you, I wonder if you want a different word, because legal process usually makes people think of due process. But secondly, I thought that unbundling that, it's not a unitary concept. So you talk about litigation costs, administrability, false positives, and private actions as being part of the US bundle that has caused the shift in the US law to be much less interventionist. I would say litigation costs could work either way, administrability could work either way. I'm thinking of tort law, in which Calabresi comes out with his wonderful book, The Cost of Accidents, and it is about administrability and costs. And he's saying that should push us to have simpler rules and maybe no fault rules. And I'm thinking also of Breyer in the antitrust cases, saying for administrability, say Calden, we need a simpler rule that gives a stronger presumption. False positives, I think, is charged and goes with my first point. The concern about false positives, if your period of time was 1980, it would be very different. But if you're concerned about false positives in 2020, I say that's ideological. It's not the real concern. It is using the name, which sounds so great. You don't want false positives. You don't want to intervene too much. Using that in support of a political ideological theory of laissez-faire, stay out. Private actions kind of fits with that. My third category is implications for the future of your whole construct, your book, your ending with your questions and your big questions of the future. And I'm left with some big questions for the future. So I tell you, and I want to know how you think about these. So my first big question comes from thoughts about globalization, China, what form of competition in the world we have today, and the very fact that, going to one of your basic premises, economic facts on the ground is what has driven very much the formulation of the competition law of the US and of the EU. If you look at developing countries, the economic facts on the ground are totally different. The markets are still not working well. State-owned enterprises and privilege still has a huge sway, and 90% of the people or more are left out because of huge barriers and inequities and inequalities. And if they were to design and formulate the law based on their economic facts, it would look different, even if it has no social value nudged in. Even if it were economics only to get the best products to the people, it would look different. And here they are. What are they to do? They're the price takers. They have almost no room to maneuver. So this is the question: what are the implications of looking at, say, US and EU and their facts on the ground are different from others, and they're the price givers. So what's going to happen in the world? Well, maybe China comes in and pushes in a different direction on industrial policy, and the coronavirus comes in and causes, in addition to the China maybe paranoid, causes everybody to become more nationalistic. And we have new facts on the ground. We were trying to get convergence in some sense, convergence of systems, even like systems working together better. What does your analysis do for these questions of the future? Thanks.
Thank you, Eleanor. Thanks also for stick to the limit of the time. So our second commentator, Ian, you're gonna go, the room is yours now.
With pleasure. I must say that when I was told by Barry that was writing a historical review that began in prehistory, I thought, oh dear, 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 this is a bit anecdotal, a bit jokey, a bit peculiar, but Barry's a nice guy, and so of course I'll humor him. Now, Barry is still a nice guy, but I don't at all feel that we're humoring him because this book puts in an overall philosophical, historical context the phenomenon of what we can call antitrust law in a way that I don't think has ever been done before. And although at different conferences, when someone has doubt what the Tsar said in 1622, oh, that's a good joke, or what Hammurabi said in whenever Hammurabi was on the throne, that's interesting. The coherence, the systematic overview of what people were trying to achieve in previous centuries is really, really, really intriguing. That's my first thought. Now, moving forward about 3,500 years, I'm very interested in two aspects, and one I slightly disagree with Barry, and one I was unaware of before, and that is the significance at the time of the formative days in the 1950s, when Europe was flirting with the notion of what we now see as being the Treaty of Rome, the European Community, and there was an early drafting moment. The pressure from the United States that an antitrust law ought to be part of that. That's intriguing, and I'm not sure that's been well recorded in the literature. That's very interesting. At the same time, looking at that period, I've had the advantage once of going back and looking in the archives of the Treaty of Rome and looking at what became Articles 85 and 86, now Articles 101, 102. And that's fun. You see the physical archives, and you see the coffee stains, and you see the scribbles and the pencil marks and the red ink and the blue ink, and really intriguing. But what struck me was the utter incoherence of some of the drafters from the 6 member states. They wildly disagreed on what it was that they were trying to do. And the drafts that were proposed originally prohibited, or one of them prohibited religious discrimination. Another one prohibited price discrimination. All these ideas bounced around, and even at the last moments, significant changes were being made. Now, it's intriguing that a text which was the fruit of such wildly divergent notions has become the basis of competition law in more than 100 countries. And so the clarity of the text isn't really obvious. As Barry notes, it's there's the triad of what we've got today. So that's one observation. Next observation: significance of the United States. There's a point where I think Barry's account maybe has a gap, and that is that during the period 1970s to the end of the 80s, during that time, American antitrust imperialism was regarded in many countries as an enforcement problem, a sovereignty problem, a jurisdiction problem. And American enforcement was regarded as being excessively hostile and heavy-handed, and there was a tendency for governments to protect their own nationals. And that changed completely with the adoption of notions of shared comity in the 90s. You enforce in your country, we'll enforce in our country, we'll share lots of information, common goals, and we'll do it together, and we won't argue about sovereignty questions. That was one big element in the change. And the second big element in the change was the adoption of a systematic leniency policy, first of all in the United States, and then reluctantly and subsequently enthusiastically for the European Union. And I think that hostility, suspicion, skepticism about US excessive enforcement had disappeared or greatly diminished with the advent of the committee, joint committee. Then the two complementary observations. It's true, in the early days when Barry and I were baby lawyers in Brussels, the notion of enforcement against national champions was quite sensitive. And European Commission officials who were too zealous in the campaign against national cartelists, were not promoted and were you might say ill-regarded. There wasn't much space for them. By contrast, the use of competition law to pursue an integrated common market was a European first. So free riders got immense opportunities, and a big apparatus developed around the use of competition law to achieve an integrated market. I think that's a world first. And now that idea has kind of been, not abandoned, but it's no longer a front-rank priority. I think we can see the approach to cartels as rejoining the mainstream. Then the notion where I completely agree with Barry, the notion that process has a big influence upon substance. I think European competition law is immensely a clear manifestation of that proposition. In the early days, European competition law had the obsession with the integration of parallel trade, with the achievement of parallel trade and its encouragement of free riders, and that had its role in those days. United States competition law was enforced in a manner which was regarded with awe out of Brussels. By contrast, today, it seems to me that the combination of various factors, including the supervision of cautious federal judges in the private enforcement of US antitrust law and the slow accretion of principles and precedents in the United States. So there's an immense body of law. By contrast, the European situation is, I think, Brussels is today probably the most radical place for the invocation of creative, interesting competition law theories. And that, of course, presents fresh, different, important challenges for review. I found, I've had the advantage of seeing I think it's the fourth chapter of the European bit, with real fascination. And I look forward to seeing the whole book, which I hope will get the intellectual and commercial success that it deserves.
Thank you. Thank you very much, Ian. Thank you, Eleanor and Barry again. We do have a couple of questions, Barry. And let me try to bring the view a little bit to Latin America, because most of our audience is from Latin America. And now that I have the monopoly here, let me just make the first question maybe. And the question is related, I think, with your last conclusion that you were not able to comment on. But I mean, my question is, how much would you say institutions matter for the successful enforcement of competition law? I mean, funding, political support, independence, adequate personnel, full respect of institutional design of the laws that created those enforcement institutions, transparent internal rules of proceedings, etc., etc. How do you think these institutional issues really matter, if any, in competition law enforcement?
Pablo? Yep.
Yep.
Okay. Well, I think they're critically important. Everything you mentioned, you put it, say, in historical perspective. One large difference between the earlier period and today's period, the modern period, was that you had a well-funded, politically supported group of people who were expert. They were specialized, or they were expert, specialization, and therefore they could consistently enforce the law over time. Well, over time and against many different sectors of the quote economy, right? That's the biggest difference in impression one gets of looking at the earlier period. It isn't so much the substantive rules, we have a system today, an enforcement system in each jurisdiction that simply didn't exist anything like that, right? Now, to be successful, and it's all true, it's most banal things, it's true, right? You need funding to attract people. You need good people, putting it that way. That covers a lot of qualities. We say someone's good, right? And work hard. The political support is necessary. I know there's a debate about independence. I read it. To me, it's an ugly phrase, but I think I agree with the idea that's an embedded autonomy. There's this debate about independence, right? And the quick, politically correct view is authority should be independent. Right? So independent of what? Right? Well, independent of the politics. Okay. Well, on the one hand, if you want to really be independent, if an authority is really going to be independent, then it has to have the ability to raise its own revenues, right? We have one example of that in the United States, which is the Port Authority of the state of New York and New Jersey, which the state legislatures in the 30s maybe made the giant mistake, later they thought, by giving that authority the power to raise money on their own. They could raise bonds on their own. That gives you independence, right? So it's sort of a funny analogy, but it's, yes, you want your authority. You don't want the political authority, the executive of the legislature, interfering in specific cases. Right? Most people would agree on that, right? But you want their support. So you want the money for the enforcement. It's about the money, right? It's for the funding and everything else. And that's so whether that makes you independent. Ideally, they say we're going to give you money and let you be totally independent. That's the ideal, right? The trick is to compromise on that if necessary, so that you get the money you need, the authority gets the money it needs, without the executive or the legislative branch interfering, either certainly in specific cases, and maybe on enforcement priorities, but that gets trickier. So that's a long-winded, to me, there's sort of common sense things that a 16-year-old could figure out. I'm big on 16-year-olds understanding things. We're smart at 16, and then we get educated and get dumb, right? At 16, you know what to do, what you need to run a good competition authority. I mean, that's aside from the expertise, right? You wouldn't have that, right? So that's my, on Eleanor's point, Eleanor's point, what would you do on my grand construct? Well, I think you want the law, the local law, the law in Argentina you probably want the common triad. So the statutes there, right? Fine. And that can be the same as it is in the US or the EU, but it's not because of the ES or the EU, it just makes sense, right? It just makes sense, right? So I wouldn't, it's not some foreign implant, right? Then on what you do with it, you look at economic theories and interpreting the law, just like everybody else does, okay? That generates a convergence. It's a natural convergence because the economics is the same. It should, it's not physics, fair enough, there's going to be more debate, but the economic laws should be the same in Buenos Aires as they are in Paris or they are in New York, right? Economic conditions are different. Of course they're different. So that you shouldn't expect convergence all over the place on outcomes of cases. That's what I'm thinking about, right? The theory, you stay with economics, you select the best economic theory, you apply the theory with the conditions. I know they reinforce each other. The conditions can be very different, so you don't worry about my outcome is different from what they're doing in Brussels or Washington. No, I have different facts, right? And on the politics, I have the politics. You want the politics to support the antitrust authority when they are fighting powerful interests in the country. That's what you want the political support for, right? Okay. And the last thing, legal process concerns, the way I'm thinking about it, again, they're banal. Of course you want legal certainty. The Romans knew that, and the Romans probably knew more about law than any of us did. So that's nothing new about legal certainty or administrative legal rules. So I would think about that, but I wouldn't have that as priority. So there we are. I wouldn't my priority. The facts change, economic conditions are different, so obviously the outcomes should be different. The theories should generally be the same. That's on your, I didn't answer Eleanor, so maybe take other questions.
Okay. Let me give the room to Nicolás Levin from Chile. He's just made a question in the chat. Nicolás, if you want to read it.
Thanks, Pablo, and thanks, Barry, for the presentation. My question is regarding how do you think all these factors you mentioned deal with the goals of competition law in terms of, are you reshaping those goals? Are those imposing new goals? You have new levels of importance of those, and how do you see that this can affect the elements of conversion and convergence between the international competition law and the difference between jurisdictions? How do you think that affects?
You're asking me, right?
Yes.
Yes.
Yeah. Okay. Well, let's stay with the not international, but in one jurisdiction, because I don't care. I don't lose sleep over convergence, right? You're in Chile, right? And you want 6 different policies, employment policies. South Africa has an express policy, not just employment, but Black empowerment, all right? Historically, they decided we're going to apply to our merger control. One factor in reviewing mergers is the merger's effect, not simply on local employment, which is politically incorrect in the United States, right? But also on Black employment. Fair enough, okay. My point is, if you're going to do that, I have no intellectual objection to doing that, right? That's where I'm coming from, right? Okay. So if Chile wants to have employment or wealth inequality as a competition law policy, that's okay with me intellectually. My point would be that this is, if you're going to use a competition law to do that, to promote that policy, then the competition law is going to be applied to business activities. Business activities require economic analysis. That's what business is about, okay? So your policies and the application of the law will be mostly an economic, it will be within an economic framework. So you've got to translate your let's say your employment law into economic considerations, or have them, let's say, merge and control employment. You don't pretend that they have anything to do with competition. You just put it in the statute saying if X number of jobs are lost in the percentage of term, the merger doesn't go through. Or there's a presumption that if X number of jobs are lost, you define that different ways, there's a presumption of illegality. You don't try to somehow, well, you could. The next step is somehow, is that unless they're not anti-competitive. I like a clear, my little bit of experience, again, with the South African merger control as a lawyer, was I had no problem with their merge criteria. The clients never had a problem representing buyers. The only people with problems were my US antitrust partners, the US antitrust lawyers with ideological objections to talking about employment considerations in a merger case. You just did it. I mean, the authority said, okay, we're reviewing your merger. The competition authorities are reviewing the merger. We're now going to talk about jobs. And we're going to discuss jobs. And it wasn't, there was no attempt, maybe this is intellectually sloppy, but there was no attempt to reconcile jobs with traditional competition concerns. So that's a long-winded, I think you can introduce non-competition policies in a traditional sense of competition into your competition law. But if you're going to use competition law, you've got to translate those policies into economic kinds of analysis, because it's going to be an economic, it should be an economic analysis. That's not easy to do, but it's not impossible to do. That's my, there we go. I think it can be done. Maybe a little sloppy intellectually, but it can be done. And if your policy is to promote Black employment in South Africa or wealth equality or whatever your policy is in Chile, that's an important policy, and you have to, would not be bothered at all by doing a little not perfect economic analysis, the competition law analysis. But
Thank you, Barry. Going from Latin America back to Europe, Iset Sinan has a question from Brussels. Iset?
Thank you. Hi, Barry, Eleanor, and Chris. Sorry, Ian. That's a Freudian slip if ever there was one. I have a question, but it goes back to your first point. So going back into history again, you were talking about some very old historical events. And I wanted to see if you had spent any time looking at what the medieval Mediterranean countries were up to on competition law. And I'm thinking in particular about Venice, because you'd mentioned that historically what you'd seen in the first period was all about grain prices, food riots, and effectively dominance. Did you ever consider what was going on in the medieval period?
Yes, but let me make a big caveat here. Most of my research was done in English language. Okay. The next was French, because I can read French, right? Enough to research it, right? Then I had a group of seminar research assistants who spoke Arabic, Mandarin, Chinese, and I used them to research on Sanskrit. So I used them to research certain societies and periods, okay? For medieval, so most of my medieval work, I did read one book in Italian. Well, I sort of read it in Italian, right? Because I sort of read Italian, right? My Latin is gone, right? So what's missing, in a sense, the book is an invitation to people, particularly language, it's language, right, most of the time, right, who could specialize in certain periods. To answer your question, I did read an article in Venice, actually, on Venetian merchant laws, which didn't have anything to do with grain. They were price fixing legislation, but I didn't summarize it. It's all summarized. There's a lot that can be done if you speak a language. It's a combination of your language facility. You can speak the language to read the original sources, not the secondary histories, right? So you have to read the original sources, and you have to ask the right questions. Questions like, the Mesopotamian cities. I don't know whether or not they had price because nobody's asking. The evidence is frequently like Hammurabi, right? This is a stone, this is a stele. All you have, and this is common, it's like the Emperor Zeno's Constituzione, right? It's one fragment. You have no information on. I'll stop.
Right. No. I just wanted to share with you something that I accidentally came across, and I'm happy to send you the slides I put together as a result of it. But it struck me. It struck me as incredibly similar to the language and the process that we're using today. And it set forth, I mean, I'm not claiming I read it in the original language, but it does come out of a book called Medieval Trade in the Mediterranean by the economist historian Robert Lopez from the US and Irving Raymond. So I'm assuming Lopez could speak his native language, so he must have looked at the sources. But what's really intriguing is it's a motion passed in the Venetian Senate in 1358 on the 28th of April, and they're talking about a cartel. And I'll just read you little snippets which shows you how I think might be helpful for you. Whereas our fellow citizens frequenting Cyprus have of late engaged in the formation of rings and conspiracies in the business of transporting cotton to Venice, entering upon mutual obligations and pacts to prevent the transport of more than a certain amount of cotton. So, you've got all the key ingredients of conspiracy, agreement, quotas, etc., which I thought was interesting. And as you go through the discussion, you see that they end up with an investigation and remedy. And again, very similar language used. They get 3 wise men, have to be elected from the assembly. who shall make an inquiry in regard to these rings, as well as powdered sugar, salt, and other merchandise, and once again, transportation. And then they have to draft provisions, give us their advice in writing, we're going to meet again, and then we're going to take the appropriate action. And the one fundamental difference is they've got to do all of this within 1 month. But the language and the notions are remarkably similar to what we're dealing with today.
Well, thank you. Please send that to me because I'll add it to the cartel discussion. That's just more evidence. I make general statement. There are a lot of laws and enforcement of laws against cartels. Florence was executing people. Early Islamic world, you had amputation for price fixing. I mean, so you've got plenty of examples, but that would I will use your example. Thank you.
I'll send you my set of slides as is, and it's got the references in there as well. If Pablo can send me the correct email address, and if Ian can absolutely forgive me for my faux pas earlier.
Thank you, Seth. We are reaching our 90 minutes limit, but let me have a couple of questions more. We have more questions going on, but I mean, Mark Patterson, your fellow colleague from Fordham, also left a question. He said, I wonder about the claim that competition law has always been about business conduct. Ergo, it's always been about economics. It makes me think of Frank Easterbrook's claim that business people know what works, but not why it works. The former is business, it seems to me, and the latter is economics. Maybe competition law would have always been about business, but not always about economics.
Well, I don't, well, these definitions. What I'm saying is that the business, well, there aren't economics, okay? What I'm saying is that throughout history, well, one proposition is the laws deal with what today we call economic activity. I think that's, you know, I think that's hard to disagree with, right? Then I think throughout history, people have had ideas about economic activity. I think some of those ideas were fairly sophisticated, right? But you can argue about that, right? But they had ideas about economic activity. They understood supply, demand, blah, blah, blah. They understood about profits. They understood about sharing loss. They understood a lot. Okay, now, what happened in the last 200 years or so, right? You argue about when it starts, we now have a modern discipline, a separate intellectual discipline called economics. That didn't exist before, which is very sophisticated. There's a lot of math to it now, but that's as a discipline that just didn't exist before. But people had ideas, right? So that discipline of economics, which is far more sophisticated, right, is still about economic activity. It doesn't have to be only about economic activity because it's become a separate discipline. So you can apply it to the law of homicide, right? Okay. I think reasonable people could argue about the relevance of economics analysis of the law of homicide, right? I don't think reasonable people can argue about the relevance of economics to competition law. So I don't know if that answers what Mark's saying, but I don't see the.
Okay. Well, we still have some questions like related with fairness. Marcelo is making a question of fairness. We also have a question of Mauricio Velandia on what do you think about 8 people allegedly owning 50% of the world's health, and if antitrust law has nothing to do on that. We still have 2 or 3 questions more, but unfortunately we are running out of time. I will let you know, I will send you the questions in case you didn't read them so that you can also exchange opinions with them, and that might also be interesting for your own book. But said that, Barry, Eleanor, Ian, thank you very much. I don't know if Eleanor or Ian want to make some final comments before we close.
I will say two things. The book is really, really intriguing and will add to my understanding. Secondly, I think that competition cases, antitrust cases are ridiculously overcomplicated by excessively abstruse economic theoreticians. We can be far, far more simple. And that's a view I sort of had as a practitioner, and it's a view which has been reinforced in my 5 years on the bench.
So for me to close, I will actually endorse what Ian just said. First of all, the book is very important and fruitful and interesting and satisfying, and everyone should get it. And secondly, Ian, I hope you write on how to simplify. There are various ideas and theories out there, and I'm convinced that you are correct. The law has gotten much too complex, losing sight of itself by handing over to microeconomists who are going to spend millions of dollars on each. The epitome of this is in the United States, the T-Mobile Sprint merger, where the judge said, both of the economists on both sides have presented something so compelling and interesting, I'm just going to go with the credibility of the witnesses.
Thank you very much, Eleanor. And I think we might have the next activity, or why not the next book, or the first book of the IDC on how to simplify things on the competition world. So thank you very, very much. Sorry, Barry, you have something to say?
Yeah, just to thank Eleanor and Ian and you. And I'm not good technically, so I would love to have the questions, which I have not managed to access. So I'll leave that to you, and I'd be very, very happy to reply to people. You can somehow get me their questions.
I'll do it.
It's not my email, so.
I'll do it. It's a commitment. I'll send you the questions right once we finish. And again, thank you very, very much. I think your book is a very important asset, I would say, because sometimes we really need to think about why we are doing what we are doing, and history has a lot to say on that. So we are really looking forward to read your book. Thank you very much for choosing the IDC to present your book. And Eleanor, Ian, as always, thank you very, very much for your cooperation and for participating in this nice event. Thank you, everybody, and see you soon.
Thank you. Thanks, Barry, Pablo, Ian. Bye,
Nice to see
everybody.
you.
Bye-bye.